Well, thank you, Scott, for putting this together, and it's a very valuable thing that we're doing here, so I hope that I have a contribution. What I'm going to do is essentially talk about language proficiency and citizen rights. As Scott mentioned, I've done a lot of forensic linguistic work, and quite often, I think because of my TESOL background as well, I end up doing things with non-native English speakers. And so first thing I want to talk about is this. I do have a tendency to walk around, but I'll try to stay close to this. Is this thing that a few people have mentioned. We're living in a couple of ages. One age is the information age, but we're also living in a thing called the age of proximity. And that means that we're all proximal to each other. We're close to each other. Throughout the world, immigration, cross-national immigration has just increased dramatically in all sorts of places. And so all sorts of countries now are wrestling with how to provide equitable services, both in education, in government, etc., and especially in the in the law with respect to criminal cases, etc., and non-criminal cases, civil cases. The United States, especially because of this particular item in an amendment to the Constitution, where it basically says that we have to provide equal protection to anyone within the jurisdiction of the laws, right? Citizen or non-citizen. And so this pops up quite often when non-native English speakers come to the United States and have to work here and at times interact with the law. And when they do interact with the law, we get this sort of, and those of us who have worked with the law from a linguistic point of view have come up to some realizations about what the law is. And in many ways, the law is what we call a secret English. So I want to just talk a little bit about this secret English. I have to say, by the way, that I'm going to be, it may be perceived that I'm going to be critical of those involved in the legal profession. And that's not the case whatsoever. I have to confess, though, that I have had some pretty heated discussions with Utah Supreme Court Justice Tom Lee about these kinds of things, and Tom and I have gone head to head with this. And so here's a question. One case I was involved in down in California, the California Board of Prison Terms was involved in a class action suit, and about huge percent, I'll say about 60% of inmates in the California prison system are either low educated or non-native English speakers. And they have to fill out a parole document to get out of jail. And this is one of the items that they have to respond to in the parole document. Although I have not filed an administrative appeal concerning a board error which adversely affects my term of confinement and or period of parole, exigent circumstances exist that necessitate an immediate hearing. I ask my students when I teach this at BYU if they understood this, and I also ask them what exigent means, okay? And we have a little discussion about that. Would you know what this means? Would you know what this means if you were 6th grade education or a non-native English speaker in the prison system and you have to respond to this, okay? Now this class action suit obviously was brought by a law firm representing a whole bunch of inmates, and this was the second time that there was a court order that said they had to simplify this. This had already gone through simplification, okay?
It's the simplified version.
This is the simplified version. You have to understand this. Why does this happen? How does this happen? It's an interesting thing that you find out when you start working with the law. There are two things that contribute to why this is happening. From a sociolinguistic point of view, we realize that most I'm going to go back to here because I don't want you to see what I just put up there. Most societies stratify to some extent because of language. We mark our status in the society because of language. So let's take a simple sentence like, I looked at the ball. So that's why I'm not showing you this other slide, because it's going to come from you. Let's say I looked at the ball. I am an academic. I have a PhD in linguistics. When I write academic papers, if I submitted an academic paper, no matter how valuable the content is, full of simple sentences that said, I looked at the ball, would that paper be accepted? Of course not. I have to twist that sentence and all sentences like it into something called academic high code English. So let's do it. I looked at the ball. Now in this high code English, we can't have simple Germanic words. We need Latin-based words. Latinize ball for me, please. Sphere. But in this high code language, if we can say 2 words instead of 1, that's even better. So sphere becomes what? Spherical object. Okay? Looked. Looked is an old-fashioned Germanic word that we use in speaking, but it's not a Latin-based word. So looked becomes observed. I observed the spherical object. Yeah, that's still not good enough, because in this high code, we really enjoy nominalizing, changing verbs into nouns. And so we like to change the verb observed into a noun. What is it? Observations were conducted, because I could say made, but no way. Observations were conducted on a spherical object by me. Who did the observations? I did. We can't say by me, that's 2-letter words, so I have to say personal observations. Now I can throw in a little bit of Latin French in there, and what I end up getting, now you can see it, personal observations were conducted vis-a-vis a designated spherical object. If I had more time, I would show you a couple of Calvin and Hobbes cartoons that do this, but I took it out because we've got to get here. People call this a secret English. Why do we call it a secret English? An Australian Aboriginal leader came to an anthropologist and says, you know, we want them to learn, not the kind of English you teach them in class, but your secret English. We don't understand that English, but you do. To us, you seem to say one thing and do another. That's the English we want our children to learn. Part of coming to the university experience is to acquire this second language. It's almost a second language. And so we have, in the English language, we have what's typically referred to in sociolinguistics as a diglossic situation, okay? A diglossic situation where there is a high code that very important stuff happens and a low code where normal people function, right? Well, obviously, high code stuff happens in the law, and the law does high code English. But in so doing, people who don't have access, who haven't gone to college, who haven't learned the high code, do not have equal access, okay? But there is also another thing that's particular to the legal code. So this is an example. This is the example where this is taken from the secret English from the Board of Paroles, etc. It's what Janet Ainsworth, who is a professor of law in Seattle, is also now, who got very interested in linguistics and is now the president of the International Association of Forensic Linguistics. And she wrote an incredibly important paper looking at, part of what we'll be doing today is looking at Miranda rights. And so she looked at the Miranda rights in terms of appeals. My goodness, Scott's waving 10. I'm assuming you're saying 10 hours, right? So, these invocations of the Miranda warnings, could I call my lawyer? Can I get my lawyer? Could I get a lawyer? Etc. have been overturned in appeals cases because they did not, they carried what linguists call pragmatic intent. Could I call my lawyer? This is the may-can thing. Can I go to the bathroom? Well, you can, but you may not, right? This is that thing. The law demands exactness in meaning. I fully understand this. The contracts that you sign have to have exactness in meaning, or else judges will be, if they're not already, just drowned in work. And so exactness in meaning means that even in the invocation of a Miranda warning, there is no room for common sense, pragmatic intent. So we've got those things happening. The magic word. Janet Ainsworth calls this the magic word. We have one other thing. This is a non-native English speaker who's being interrogated. I'm going to go through this quickly. This is a long interrogation. He ends up giving a false confession. He comes in, he's put in the corner of the room. This particular officer he's talking to is a native Spanish speaker. And then the other officer is an English speaker. He turns to the native Spanish speaker and he says, "You know Spanish?" The native Spanish speaker says, "Poquito," a little. "My English kind of limited." And then the interrogation begins. The interrogating officer is following the Reed technique, a technique where basically it's high-pressure, coercive interrogation. He's at the pressure point. There are certain steps. He's at the pressure point. And then we get the breakdown and the confession, and it's a false confession. The people most vulnerable to the Reed technique are people who have non-native English speaking proficiency, women, low-educated folks, okay? And so linguists get very much involved in these kinds of cases. All right, so one reason for this is the culture of what we call the power distance index. Essentially, this means different cultures relate to power in different ways. And so if you have a high differential notion of power versus a low differential notion of power. A low differential notion of power means I can stand up to anybody who's got power because I am an individual. What's common about the top 5 versus the low 5? What's in the bottom 5? English speakers. This seems to come with the language. What's common about the top 5? Lots of our immigrants, okay? So, all right. This comes from the Harvard Latino Law Review article that Judge Davis wrote and that I sort of tagged myself to, that all new incoming judges, but the American legal system, unlike its people, however, speaks only English. Here's some examples from that. So the officer thought that no entendido meant no English, right? And then another example of that. All right, I'm going to go through very quickly. Here, well, we don't have time for this, but I think later on Margaret's going to be talking about fake comprehension. All of us know that who have acquired a second language know, I bet you've been in these situations. You're communicating with somebody in this second language. You've really got no clue what's happening, but you're pretending to understand it, right? Because maybe later it'll happen, it'll come, okay? So we call that fake comprehension. And there's a prime example I did for a young man down in Vegas on fake comprehension. Here are some examples of officers working in the Miranda Provision. I'm using this. We're not only focusing on Miranda, but I'm going to show you a video. It takes 8 minutes, so I know I'm over time, but yeah. talk to the judge. I'm going to show you this video. Look at what's the dynamic between the officers and the suspect. We've got interrogator language, low-frequency vocabulary coming from the officer, magic words coming from the officer, meaning words that carry all sorts of legal meaning, like exigent circumstances, low-frequency grammar, speech rate, syllables per second. Lots of research has been shown, and we know this, those of us who acquire a second language or third or whatever, or 10th language in Rob Leonard's circumstance, that when people speak quicker, we don't understand them, right? So low speech rate is a factor, and all sorts of research has shown that there's like a threshold. You exceed that threshold, and comprehension decreases dramatically. Then look at the suspect language. There's a declaration of language proficiency. He's struggling to comprehend, lots of fake comprehension. And look at his responses to queries. Do you understand? And in that, he often just repeats what he understands. So I'm going to press a play button, and if I had like 3 hours, we would analyze this. But we don't have 3 hours. Just listen to this. It seems to me, this is my final plea, but it seems to me that we have to train interrogators better. We have to basically say, if you think you need an interpreter, you need an interpreter. Because this keeps us very busy. This ties up the system, right? It's, as we say in that article, this is a very expensive thing. In a couple of weeks, I'll be down in Houston dealing with a case. It's almost exactly the same with this. I regularly do it. Margaret regularly does it. I think Ananta does it. It's law enforcement has to do this better. And the key, I think, is an interpreter. Okay, I'm done. I apologize for going over.